next case that the court will hear is case number 28860, Timber Top Apartments versus Karen Klinkiewicz. Each party will have 15 minutes to present their arguments. If you would like to reserve time for rebuttal, please let the court know. The oral arguments are, of course, being recorded, so please keep your voices up. You've read the briefs and are ready to proceed.
Thank you. May it please the court, Neil Irewall for the appellant, Karen Klinkiewicz. I'll reserve 5 minutes for rebuttal. Your Honors, the facts of this case are not in any dispute. My client, the tenant, rented an apartment with a lease through the defendant. She, with the consent, terminated the lease early. She moved out. However, despite that, the landlord filed an eviction action against her, including a second cause of action for damages. There is now no dispute that service was attempted by FedEx. And you will see as you review the record, the docket will show it was sent out and came back as undelivered, unsuccessful.
Sent out to the Timber Top address?
Yes, it was sent out to that address and it came back, and no one is disputing that. It came back undeliverable, unsuccessful. It was never accomplished.
Had she moved from the Timber Top address?
She had.
The action had been filed?
Absolutely, yes.
Did she turn the keys in prior to that time?
Well, it's not in the record, but she did. And she gave a forwarding address, but that's not in the record either. But in any case, then they say they sent out service by posting. How the posting was done is unknown. Where it was done, unknown. In what manner it was done is unknown. It was just somehow posting was done. In any case, it came for the eviction hearing on the first cause of action. And before the magistrate noted we're here on a posting for service, and based upon the evidence, eviction, first cause, writ of restitution granted. Then the plaintiffs withdrew their motion or their cause of action for the second cause of damages, and that was it. My client, who knew nothing about it, tried to rent another apartment from another landlord months later, and that landlord ran a background check and said, oh, you have an eviction, I'm not going to rent you this apartment. And my client was, eviction? What eviction? I don't know anything about an eviction. And that's when we filed it. That's when she hired me. I reviewed the record. I filed a motion with an affidavit saying that she wasn't living at the premises, she never got service, she never knew anything about it, she didn't have any concept, whether actual or constructive, notice of the eviction hearing. And the defendant is not disputing, or the landlord is not disputing any matter in this appeal that she didn't know anything about it, she wasn't living there, she never received actual constructive notice. And we asked the trial court to vacate the eviction. And the trial court refused, saying no, service was properly accomplished and therefore denied. Well, we are challenging that up on appeal, and I cite case law, numerous case law that says when you do an eviction under the statute 1923.06, you have to do an eviction through two methods. One is by ordinary mail, and two, by posting in a conspicuous place. Now here, everyone is in agreement, there was no service by ordinary mail. There was an attempt by FedEx, but at least 2 weeks prior to the eviction hearing, everyone knew it was unsuccessful. So we're arguing they never had proper service. Further, my client submitted an uncontroverted affidavit saying she didn't know about the eviction, she wasn't there at the premises, she didn't live there, she never got the notice, had no way to defend it, and we asked that it be vacated. Now, on appeal, the appellee is not disputing the facts, but they're basically saying, so what? So what that she didn't know anything about it? Once they attempted service by ordinary mail, the fact that it was not successful is irrelevant. There is no guarantee, and there's no requirement that she has to know about the eviction. All that has to be done, according to them, is that it was sent out. Whether it was successful or not is immaterial. Whether she knew about it, whether she had a chance to defend it, that is not material for service in the landlord-tenant complaint. Now, in response, I cited, and they rely on a case to support that position. However, the position of that case, GKG Builders versus Burgess out of the 6th District, when you read the facts of that case, does not support that position. And in fact, the 6th District, in a case that came out in 2016, after that, extremely limited the holding of Burgess of saying if we even said that. And I cite this on page 2 of my reply brief. And there they said, it's very similar facts to this. The tenant didn't know anything about it, submitted an affidavit saying I never got service, I'd like the judgment vacated, and the Court of Appeals agreed. And there they wrote, and this is on page 2 of my reply, finding that due process was not afforded in this case does not frustrate the purposes of forcible entry and detainer actions. FED actions are not so extraordinary as to suspend the fundamental tenets of due process. Our determination that appellant did not receive due process under the facts of this case does not hamper the service procedures for the landlords under the local rule or RC 1923.06. As long as such procedures are reasonably apprised the tenant that an action has been initiated against it, such service affords landlords under the statute is proper and not subject to later attack by motion to vacate. So again, all we're asking the court to do is say, because there was defective service, which all parties are really stipulating to, that the motion to vacate should be granted and this eviction action taken off the record.
Isn't sending the, using the address of the apartment for purposes of service reasonably calculated to give notice to the tenant?
If she was still living there, I would agree.
What evidence is there that they knew she was not living there?
Well, we have submitted an affidavit saying she wasn't at the time of the eviction, and they're not disputing that. They're in agreement. Yes, we understand she was not living there at that time.
Did Kindertop, I guess, that's the question, did they file an affidavit in response to your affidavit?
They did not. That's why I'm saying it's an uncontroversial affidavit. They're not disputing the facts as laid out that she didn't know about the eviction, she wasn't living there, had no notice of it, actual
And there
construction.
was no hearing held on that?
On the motion to vacate?
Right.
No, we filed it, and the judge has issued his judgment denying it on its face. So, if there's no further questions, I'll reserve the balance of my time for.
I have one, counsel.
Yes, Your Honor.
From the order appealed, the writ was issued, was it not?
Yes,
And the writ has been fully executed.
correct.
What's the remedy that your client seeks
We
in
want,
that event? Because, go ahead.
oh, the eviction is on her credit report, and she cannot rent a new apartment because of that. We want the judgment of the eviction, the writ of restitution vacated and taken off her record, because that is preventing her from getting another apartment. And we put that in our affidavit too, that the first time she found out about it is when she tried to rent another apartment and that landlord refused because you have an eviction like in a few months ago, so I'm not going to grant it. So if you vacate the finding of the eviction, well actually, legally speaking, if you vacate the default judgment, you go back to what it was at the time of the filing of the complaint. And if she's moved out, we would then argue mootness and the whole case should be dismissed, but that's a matter for the trial court. But as far as this court is concerned, once you submit an uncontroverted affidavit of defective service, this court has held time and time again that the motion to vacate should be granted at that point. So with that, Your Honor, I'll reserve the balance of my time. Thank you.
Other questions? All right. All right, good morning, Counsel.
Good morning, may it please the court, Your Honor. My name is Dean Constant, and I represent Timbertop Apartments, the applicant in this case. First thing I'd like to do is respond to some of the comments made by appellant's counsel. The extent of the record, besides the documents that were originally filed up to the time of the filing of the motion to vacate, there was a single affidavit that was prepared and filed by the appellant. Nothing in that affidavit states that there was a consent to leave early. There was never anything in the affidavit stating that the keys were turned in response to Judge Theodosio's question. So the facts essentially are not in dispute, but there's some additional facts that are being brought up here today that I want to clarify. We are not questioning that she may have not have been living there, because we have no notice whether or not she was living there or not. But to answer the question, did we know it at the time? Absolutely not. Timber Top Apartments is not in the business of spending $169 on each one of their evictions to evict somebody who's already gone, okay? And the issue then comes up to, let's think about, are they living there or not? We are not here to determine whether or not a tenant is living at the premises. What we're trying to determine during an eviction proceeding is their possessory interest that the tenant still maintains. Numerous times tenants move out and they leave their things there. Numerous times they maintain their keys. And as you alluded to, Judge Theodosio, the whole symbol of taking possession and giving back possession rests with the keys. You rent an apartment, the landlord gives you keys. When you leave an apartment, you go to the landlord and you turn in the keys. That's not in the record whatsoever. And in this case, when Timber Top filed this eviction action, it was no different than any other eviction actions that we filed in the court. It was a two-cause complaint. First cause, forcible entry and detainer. Second cause is always the money damages, typically because they haven't paid their rent. Let's face it, 99% of all evictions are based upon not payment of rent. The second cause was dismissed with the warrant of prosecution. And the reason I bring that up is because the warrant of prosecution is because we didn't do anything further because we could not obtain service on the second cause of action. There's a distinct difference between a eviction action and a money action. One's in rem, one's in persona. 1923-06 is the statute that the legislature passed in order to deal with forcible entry and detainer actions, not the civil rules. When the defendant appellant filed the motion to vacate, all the arguments were predicated upon the civil rules. Civil Rule 1 clearly states that forcible entry and detainer actions are exempt from the civil rules. Every case that the appellant cited dealt with the civil rules. Only one case that he cited dealt with service on 1923-06, and that's the Jean-Pierre case. In the Jean-Pierre case, at first blush, is a little bit worrisome until you really read it. And what happened in that case is that the 6th District Court of Appeals, years before, determined the constitutionality of 1923-06. The problem with 1923-06 is a provision H2. And if you look at H2, what the legislature was attempting to do was, hey, say, look, this is an interim proceeding, it's a summary proceeding, all we need to do is put notice to the apartment. But then they turned around and said, oh, by the way, if you add other claims to your eviction case, that service is good also, as long as you follow the statute. My humble opinion, that was a major mistake. And it all came to fruition when you see the Jean-Pierre case. Because what happened in that case was a doctor who was living in Solon, Ohio, needed to rent an apartment in Toledo because he's working in Toledo as a doctor. Never moved in the apartment. Had a pro se landlord file an eviction action in Lucas County knowing that he wasn't living there, and added a second claim or second cause of action for money. He proceeded to get a default judgment, a personal judgment, based upon service under 1923-06 and not under the civil rules. The 6th District then realized what the mistake was. This was totally unfair and inequitable. So what they said under those circumstances is, oh yeah, he should have been served. They didn't come out and say he should have been served under the civil rules, but he should have been served under the civil rules. That's precisely why, in our case here today, we let the second cause of action die. We didn't know where she was. We could not obtain service on her for a personal judgment. This is an in rem proceeding. And in rem proceedings, service does not need to be made on the person, and it's not a defense to say you did not receive it. If that was the case, Civil Rule 4.4 would be all for naught. 4.4, service by publication. Undoubtedly, people are served all the time by publication, but they don't read it and they don't get service. The judgment is still valid. Where the misunderstanding is in this case is that asking the court to issue a writ of restitution is an in rem proceeding. That means we are suing the property, not the individual. They posted on a door for that individual and all occupants. It is valid against the whole world, whether they got notice or not. And the only thing that TimberTop did in this action was request the apartment because they had not regained possession again. We obtained service under 1923-06. Because service is complete when the summons and complaint are deposited in the mail and the bailiff goes out and posts the summons and complaint on the door. Service is perfected. We are not disputing she may never have gotten it, but that's not the test. The test is, was service perfected? Undoubtedly service was. And again, I want to state to the court that the test is an abuse of discretion standard. When the motion was filed, it was predicated upon the civil rules. In my response, I pointed out civil rules have nothing to do with this. It's all 1923-06. The trial court followed that logic. And that was the basis of the trial court denying the motion to vacate. If there's any questions, I'm finished.
All right, thank you.
Okay.
Up to 5 minutes for your reply.
May it please the court. In rebuttal, when you go through the affidavit, number 2, and this is from Karen Klinkiewicz, the appellant, that all times through the proceeding of this case, from the filing of the complaint to the entry of final judgment, I was not living, and she gives the address of the residence. And they said, well, we didn't know that she was not living there. It is undisputed that she was not living there at the time. Now, they cite services completed regardless if she knows about it or not. That is not in accordance with this case law, or with the case law of this circuit, or any other that I can find. As a matter of due process, as a matter of knowledge, whenever a tenant leaves, you could always just serve her address she's vacated, have it posted there, get whatever judgment you want, and then she may not find out about it forever, or months, or years later. That's exactly what happened here.
Well, his argument is you would not be able to get a money judgment against her. You would be able to get the interim relief of the eviction, but not the money judgment.
Correct, but as I point out in case law, both out of the 8th, and this is on page 7, Corey versus Sullivan Bushman, that was an eviction action, which they vacated. And even the one I read earlier, Romp versus Jean Pierre, those were all eviction actions as well. Now, they said it's against the property, but that's not true. It's not in Moon Department 4. It is landlord versus tenant. It is an action against her. It is her rights that are being implicated. And in fact, as we sit here today, she still cannot rent an apartment based upon the eviction that was falsely obtained against her. Now, they're saying it is immaterial that she does not know that there's an eviction action against her. He's citing no case law in support of that says that you could just get a default judgment basically on an address when they know she's not there. I don't understand that argument. If she's not living there, and again, they're not disputing they know that she wasn't living there, then how can you just file an eviction action? And they knew 2 weeks prior to the hearing that FedEx service was insufficient and failed.
So your argument that 1923-06 requires the due process that you're arguing here today?
It requires 2 things, Your Honor. It requires service by posting in a conspicuous place. And again, there's no evidence that that was accomplished, and we're disputing that. And second...
You know, I have a question about that.
Yes, Your Honor.
They say they posted. How can your client say, I wasn't there, and dispute how it's posted? You can't have that both ways.
When you read the transcripts, Your Honor, it is their burden to prove that it was done in a conspicuous place. That's what the statute requires. When you read the transcript, there's no evidence of that. So we're saying, based upon the evidence presented, there was no posting by conspicuous. And he said it's abuse of discretion. That is not true. This court has held whether service is accomplished or not is a question of law, and the question is de novo. This court has to make a de novo review. Was service actually done or reasonably calculated to apprise my client of this hearing, or of the eviction action? And because that was not done, we're arguing that the trial court erred in denying our motion to vacate, and we'd ask the court to reverse the remand. Thank you.
Thank you both for your arguments today. The court will take the matter under advisement, issue a decision in due course. Clerk of courts will make sure that you receive a copy of the decision in the mail. And of course, the decisions are also posted on Supreme Court of Ohio's website if you want to keep an eye out there for the decision. Thank you again.